Good evening, Crime Talk aficionados. This is Scott Reisch of Crime Talk. It is late, but I wanted to come to you this evening, and I wanted to come to you earlier, but due to things that come up in the practice of law, had a late meeting this evening. And what I want to talk about tonight is the Supreme Court decision that came down Monday that has huge implications for both the Fifth and the Eighth Amendment to the United States Constitution. Additionally, what this decision did, it basically overturned 60 years of precedent, which is law, by the Supreme Court, and it relates to the death penalty. And regardless of what side of the issue you are on, this has huge ramifications. If you're opposed to the death penalty, you are not going to like this. If you are pro-death penalty, you're going to say, game on. Let's start utilizing it. And so it clearly depends on what position you are, where you stand as it relates to this. So on Monday, 5 justices of the Supreme Court, it was a 5-4, what they refer to as a plurality decision. It basically overruled decades of Eighth Amendment precedent in a quest to let the states continue with the death penalty. And lots of states have the death penalty. A lot of states really never utilize it. And a lot of states are in the process of trying to repeal it. It was before the legislature here in Colorado recently, and looked like it was going to pass, and at the last minute it was basically tabled, so it will remain on the books. Now, some people are opposed to the death penalty for moral reasons. Other people are for the death penalty for moral reasons. And what it really comes down to is, like, what do you want to, what you stand for? People can have differing opinions, but most people have an opinion, and they're usually adamant about it. A lot of people never really think about it in their daily lives until it either affects them or someone they know, or maybe they get selected for a jury and everybody wants to know, is this going to be a death penalty case? As in most homicides. I can tell you, most homicide trials, the judge will actually tell the jury that this is not a death penalty case, because a lot of people are like, hey, I just don't want to deal with this, not my thing. And so what happened is, over the course of the last 60 years, the Supreme Court has basically said that there is this evolving standard as it relates to the death penalty. And way back in the early 70s, it was actually found to be in violation of the Eighth Amendment, which prohibits cruel and unusual punishment. But now, the Supreme Court has basically given a go-ahead for it. And it involves a case out of Missouri. And the defendant, who's on death row, he killed his girlfriend, her new lover, and her child, and he's been sitting on death row, basically waiting to be executed. And he has a rare medical condition called cavernous hemangioма. And this disorder that he has basically covers his body, his skin, with tumors filled with the blood vessels. And they're on his neck and his throat, lips, and it makes it difficult for him to breathe. And apparently, if you have this condition, you are basically sensitive to having these vessels break and squirt. And so at a hearing, Mr. Bucklew, I think I pronounced that miscorrectly the first time, Mr. Bucklew brought in doctors to testify that if Missouri had administered a lethal injection to Mr. Bucklew, he would die a slow, agonizing death, that his tumors would rupture and fill his mouth with blood, and he would suffocate a death of unbearable pain, choking, convulsions, and basically die on the gurney in a painful fashion. And so obviously the Eighth Amendment prohibits cruel and unusual punishment, but the Fifth Amendment allows for the death penalty because it clearly states that the government can take your life, your liberty, or your property, but they have to give you due process of law, which is basically, we're going to give you a fair trial, we're going to give you appeals, and then we can take your property or kill you if it is determined that. And so, like I said, over the last 60 years, the court has basically come about and had this evolving societal standards that exists. And basically it says, well, you can't you can't have a death penalty for example, a juvenile. If someone has a very low IQ, you cannot do the death penalty on them either. And they're basically arguments under the cruel and unusual punishment. And there's two precedents whereby Bucklew sought to stall his execution by lethal injection, arguing that it would violate his Eighth Amendment right to cruel and unusual punishment. And there's precedent for that. It's Baze, B-A-Z-E versus Reisch, and Glossop v. Gross. And in those cases, they challenge the method of execution, providing that the state must provide a alternative that will cause less pain. And so Bucklew asked that he be killed by nitrogen gas so that he can die from hypoxia, which is a lack of oxygen, and he would die faster than lethal injection. So in the Bucklew case, the court rejected that claim by a 5-4 decision. And Neil Gorsuch, who is a relatively new member to the Supreme Court, formerly from the 10th Circuit here in Colorado, basically says, no, doesn't matter anymore. And so basically, like I said, they overruled some 60 years of precedent, including several written by Anthony Kennedy, which was kind of that swing vote that was on the Supreme Court, and he kind of went along with his evolving standards. Now, Clarence Thomas and now deceased Judge Anthony Scalia consistently rejected this evolving standards, which was rejected by the court for so many years. But now it's got a new audience. And he basically writes that if a death row inmate seeks to avoid a certain method of execution, he must identify a different one that can be feasibly administered. And so why does the Eighth Amendment prescribe such a test? Well, the court explained in Baze v. and Glossop that because it's settled that capital punishment is constitutional, that there must be a constitutional means to carry out an execution. And because there's always some risk of pain that's inherent in any execution, the court held that the Constitution doesn't require the avoidance of all risks of pain. And that's really the argument that's been made for many years as it relates to the death penalty opposition, was because they said, hey, you can't put somebody to death. You're no better than what they did if you do this, and basically you have to don't cause any pain. Supreme Court says, no, that's not the case anymore. And basically what it says is the state simply has to ensure that they don't impose a risky method of execution when a less painful method is at their disposal. So, and basically Thomas and Scalia went further in cases where they argued in the minority opinion, said the Eighth Amendment only prohibited states from intentionally making executions more painful than they had to be. And Justice Thomas wrote in Baze, B-A-Z-E, an execution only infringes upon the Constitution when terror, pain, or disgrace are super added. All right. So as long as the state doesn't super add pain to the execution, it's complied with the Eighth Amendment. And Justice Thomas's theory would effectively shut down challenges to every method of execution unless an inmate had evidence the state was sadistically or gratuitously increasing the pain of the deaths. Thank you, Charlene, for that super chat. And so the majority of the court didn't adopt Thomas's view in either case, but in Bucklew, Gorsuch writes that revisiting that debate isn't necessary, but then he does exactly that. He adopts Thomas's interpretation of the Eighth Amendment, effectively overruling the 60 years of precedent. And why does precedent matter? Well, precedent, stare decisis is what our justice system was based upon, is that from these cases you can predict what the court would do in the future. And so what it goes on to say is that that executions they're almost expected to be painful. Let's face it, the state is then killing somebody, and that's what it is. Now, Addie's mom, super add. I know that's the word that they use. So basically, it means the state cannot go out of their way to inflict pain, excessive pain. All right. So now, Gorsuch basically goes on and says that the methods of execution permissible when the Eighth Amendment was ratified included hangings, which is basically, the force of dropping that could break the neck and sever the spinal cord, making death almost instantaneous. More often, they would die from loss of blood flow to the brain, which could produce unconsciousness, usually within seconds, or suffocation, which could take several minutes. And in the opinion, Judge Gorsuch actually gets into some quite gory details about that I don't need to spare you on, or I can spare you on those tonight. But if you wanted to see that, he actually goes on and he says that hanging was permissible because it wasn't intended to be painful, which is basically the Thomas test, and not the Basie-Glossop test that the court had previously adopted under the Eighth Amendment. So what basically means is that the conservative side of the court now has basically opened the door to executions and limited now the defendant's ability to show that there's anything wrong with it. So according to Judge Gorsuch, in this particular opinion, the question in dispute now is, in this particular case, is whether lethal injections cruelly super adds pain to Mr. Bucklew's death. But that language doesn't come from Basie or Glossop. It comes from Thomas's separate opinion, which were joined only by now deceased Justice Scalia. And if anyone knows Justice Scalia's opinion, he is an originalist. And an originalist is someone that says you have to read the document, whether it be a contract or the Constitution, at the time that it was written, drawing all meaning and effect to the words at the time that they were written. That's what originalists say. You read the plain language and you think that it's what was acceptable at the time that it was written. And obviously, hangings were permitted. In fact, hanging of children were committed. Instead, now they rejected this evolving standard of decency of a civilized society, which is kind of developed. And if anyone's watched the death penalty debate over the last couple of years, that's been the standard. It's like, hey, we're civilized, we're better than this, therefore we can't do this after all. And so forcing the states to use a less painful of the execution methods, the court adopted a non-originalist view and basically the Eighth Amendment, is that you have to require a civilized death. And so Judge Gorsuch, in the Bucklew decision, for lack of a better term, gutted the logic and replaced it with Thomas's hard-line originalism. And like I said, originalism is what goes into the reading of the document at that particular time. And so in the Basie and the Glossip case, Scalia went even further in both cases. And there he argued, as originally understood, the Eighth Amendment only prohibited states from intentionally making executions more painful than they had to be. And Thomas wrote in the Basie opinion, in a dissent, that an execution only infringes upon the Constitution when terror, pain, or disgrace are superadded, like I talked about a few minutes ago. And so what happens now is that the Supreme Court has effectively shut down challenges to every method of execution unless the inmate, it makes it somewhat hard for them to do, shows that evidence that the state was sadistically and gratuitously increasing the pain of the death. And that's, been the view over the last several years as well. We're not going to do firing squad, which is still permitted, I think, in some states like Utah, hanging, gas chamber, electric chair, etc. And so, even then, it wasn't the type of thing whereby they're just going out of their way to cause pain. And that's, if you think about it, at the time of the drafting of the Constitution, that's what they didn't want. They didn't want the king taking you to the gallows, torturing you, and then, then killing you. You have to make it kind of quick, as painless as possible. Just don't be gratuitous about it. And like I said, Gorsuch, in this case, opinion adopted Thomas's view, and he goes on about it. Gorsuch rejected Bucklew's claim, asserting that he failed to prove that death by nitrogen would really be feasible or less painful. Gorsuch also goes on, he cast doubt on the vast range of precedent built on the evolving standard of decency, rule by substituting it for the super ads principle, which is now the law of the land. Basically outlined executions of minors, mentally disabled, and individuals who committed non-homicidal acts all rest within this evolving standards of decency rationale. So the decision strictly limits the imposition of life without parole for juvenile offenders. I mean, there's been a lot of cases quite recently that have done this, and really kind of turns death penalty law on its head. And I'm surprised it hasn't been in the news more, the significance of it, but that's why we're here to talk about it. I've told you the reason we started this channel is we wanted to provide more information to this. And to somebody asks, is this a pro-death penalty chat? No, I'm not taking a position either way. If you look at the Constitution, it says executions are permitted. It's up to the states whether they want to actually have it. No one wants cruel and unusual punishment by the government in any way, but it's your decision to decide. No one's here saying the death penalty is good, death penalty is bad. People need to make the decision for themselves. And there's lots of arguments pro or negative, or against the death penalty. We can talk about in just a minute, but it's this is just significant because it really just changes the law as it relates to everything. So the question is now is whether the other shoe is going to drop, and whether Justice Kavanaugh is willing to veer even farther along with Judge Gorsuch on his originalist interpretation, and basically overturn Kennedy's position that juveniles cannot be executed, or whether juveniles can't have life without parole. And so we may find out maybe as early as next year as cases come on as it relates to minors, people with disabilities, and those who committed crimes other than murder. And like I said, now the test is this super added pain that is the standard, and death penalty jurisprudence has been changed. So let's quickly talk about the death penalty. Some people are absolutely opposed for it for moral reasons, saying you should never take a life. Other people are against it because they don't want the state taking anyone's life, because basically we're better than that, and that we should house them. Other people say, wow, it takes a long time for someone who is actually sentenced to death to be put to death, if they are in fact ever put to death, because of the appeals that seem like they go on and on and on. Some people hey, if you're going to have it, you need to utilize it so it becomes a true deterrent. There's studies out there that say that the death penalty is not a deterrent really to anyone, even the people that obviously didn't prevent them from committing the crime that brought them there. It doesn't seem to have a deterrence from people killing other people as it relates to the death penalty. And other people are opposed to it because just the cost. For example, I think we've talked about this in the past. It's literally between $32,000 and $38,000 to house a prisoner every year in prison. But it could take tens of millions of dollars for people to go through the appellate process, to have the attorneys do their work, always looking for a new angle to come up with as it relates to that. And really, this is really going to create more litigation and throw a lot of things in flux, because if the state can now execute people, and a lot of the debate has been these days on the lethal injection, that it doesn't really work. It is in fact more painful because they're suffocating. It's just more painful. But now the Supreme Court has said it's death. There may be some pain to it. So as long as the state doesn't go out of their way to add some grotesque pain to it, it's completely legal under the Eighth Amendment. And there's, like I said, whether you're for the death penalty or against the death penalty, this adds fuel to your fire. If you're for it, you're going to say, hey, let's game on. Let's start executing people. If you're against it, you're going to say, oh my gosh, we need to change this. How do we go about changing the law? That's something that's been declared completely legal as it is under the Constitution. So if anybody has any questions or opinions about that, we can do it. OE Ranger, it's less than $1 for a bullet. It is true, and most firing squads have, I think 8 people, so they don't know exactly who's the one that fired the shot if everybody's aiming for that. And some states still do have death by firing squad, and they've always been challenged on, is it cruel and unusual punishment? What's significant is the interpretation, most people's interpretation. An originalist's interpretation of the Constitution is you read the language, the plain language of the language at the time that it was drafted. And a lot of other people have this opinion that the Constitution is a living, breathing document, and that you need to be able to change with the times and reflect societal changes, and you don't have to go about having the Constitution amended because that takes too long, it's hard, etc. Now, there is a way to amend the Constitution. It's been amended many, many times over the course of our country, and it's not impossible. So if you don't like a law, you have to change it. You just can't ignore it. And whether it's a living document or not, then that's really what it boils down to. Now, think about it. We'll give a shout out to Ryan and Annika there. But think about it. If you have a document, let's say it's a mortgage, and you own your house for 50 years, you pass it down, your family has a piece of property. And depending on what that document says, you relied upon it. Your heirs have relied upon it. And so if somebody goes to court and says, well, those words don't really mean what they say, they mean something else because we're trying to accomplish a greater good, so to speak. You'd say, but that's not what the document says. And then some people say, yes, but we're coming up with the just result. And one of the things that we want in our legal system is consistency, predictability. That's what people want. They want to know and says, this is the law, and it's going to be interpreted the same way every time. And so, that's really what it comes down to. It depends on how do you want to, are you a system of justice whereby the rules are followed, or you just want to get the result that you want? That's often been referred to as judicial activism. I've had a case once where I said, Judge, the state did not comply with the law. It said that they had to do A, B, and C, not A, B, or C. And the judge looked at me and said, well, Mr. Reisch, there is some case law out there that says and really could mean or. And she said, what do you think about that? And I said, that would be completely intellectually dishonest for the court to come to that conclusion to achieve the result that they wanted. Your job as a judge is to call balls and strikes. Your job is not to come to a just result. Your job is to interpret the law. If the law is bad, send it back to the legislature and say, this is the problem that we have with the law, and this is the result that we're getting. You don't have judges change it. That's judicial activism. You have to have judges that are simply there to call balls and strikes. That's it. Not to come up with the result that they want. It would literally be if you went to a baseball game and the umpire came out with the opposing team's hat on instead of their little black cap to say this is the strike zone. And if he changed the strike zone because he liked a particular team, you would cry foul and you would say, this is unfair. The rules are changing. Where is the certainty? Where's the predictability? This goes against the rules of the game. And a lot of people are okay with that as long as it comes up with their result, which is, I guess, great if you get the result you're looking for, but it's bad if you are getting the result, you're not getting the result you're looking for because you relied upon what the law was and what the word said. And for judges to create new meanings to the plain, simple meanings of words, frankly, it's unacceptable. Okay, let's see, Joan. Oh, come on. Strike zone versus murder? Come on. It's an analogy, but that's the same thing. If the judge isn't, just like the umpire, isn't calling balls and strikes, but he's trying to achieve a particular result, that is unacceptable in our court system. And so whether you like it or not, unless you're the one going to court and you're doing it, and don't get me wrong, as an attorney, I have had to argue that you shouldn't read those words that are plain language. And I've also had cases where it said you have to read the plain language, and that's it. And that obviously is the job of the attorney, but the judge is the one that's there supposedly to simply interpret it, not create law. Only legislatures and Congress can create law. Judges are not supposed to do that. Now, obviously, the Supreme Court sometimes has been referred to as a super legislature because they decide what is the law and what isn't, and it completely go against what the population may want or may be asking for. And they said, hey, we didn't get to go through the process of changing the law, letting the states decide individually as to what they want. I mean, we're a constitutional republic, federalism. It was originally designed that they did not want central control from, the federal government. They didn't want that. It just simply is, that's what the founding fathers wanted, and you can ignore it, but those are the facts about it. Someone had a question here. Let's talk about it. And sometimes people use the super chats, they're highlighted and they stay up a lot longer, but Raisin Kane, Scott, what made you want to become an attorney? Well, I can tell you, I was the first in my family to go to law school, first in my family really to go to college. And I became a lawyer because, frankly, I worked in a law firm during college, and I thought, I can do this. And just like, many people can, I wouldn't recommend going to do it yourself without some legal training. But a lot of people that I know went to law school because they want to change the world. If you go out to law school, most of the people getting in want to save the world and things of that nature. Other people, very few people are like, oh, I'm there to make a ton of money. But clearly a lot of people do that. And even people that I've known that have said, I'm here to change the world, they go to work for the public defender's office or a not-for-profit, and then they realize, hey, I can't afford to make a living. I can't buy a house. I need to go make some real money. And then oftentimes they go do law that they do not necessarily want to do. The other thing with the death penalty that obviously worries a lot of people is the fact that you have lots of people these days who have been exonerated through DNA evidence that were literally sitting on death row, and they were there. They were going to be killed, and then they were able to stay the proceedings through a lot of these appeals that people complain about, and they're exonerated, where we were basically going to kill an innocent person. And obviously that's not right. And there's a great quote that says the American judicial system is absolutely terrible, but it's better than anywhere else in the world. And I absolutely agree with that. And anytime you put human beings in charge of it, it is going to be a flawed system because you have emotions involved. You have people that don't want to follow the law, that they want justice. They want somebody to pay for something. And those type of emotions get in the way of it. And it goes against what our legal system was founded upon. The jurors and judges are supposed to remove themselves from the passion of the fight, so to speak. I just did a very difficult case where, frankly, we thought we would win. If it was a scorecard, you would have thought we would win. But the jurors were of the mindset that there's dead children, somebody's got to pay. And that's where, the jury kind of made their decision on. Okay, I get that. That's why there are appellate courts to look at that. So when they read it on the plain transcript of the paper, they remove themselves from the emotion of it. Because at the trial court level, there is emotion of it. You got judges that want to be retained. You have, jurors that want to go back into the community and not be ridiculed for the decisions that they made. Maureen Smith, was the death penalty deemed unconstitutional? No. There's a case that just came out of Missouri from the United States Supreme Court. Just kind of recapping here, we won't go too long, but basically it says that no one has a right to a pain-free execution. The state just simply does not have to go out of their way to make it gruesome and more painful than it actually has to be under the new Bucklew case out of the United States Supreme Court. And so it's simple in that regard. Not only does this not make the death penalty unconstitutional, in fact, frankly, bleeds new life into it, because it says, we're not going to, it's now up to the prisoner, not the state, to have to show that they can have the death penalty go forward, and it doesn't have to, it doesn't violate cruel and punishment if somebody feel pain. Adrian, 411, thank you for the super chat. Thanks for tuning in, and glad you were able to catch your favorite channel, Crime Talk, here at scottreisch.com. Appreciate that. Now, on another note, just want to let you know, if you go to scottreisch.com, you can also see all the original discovery from the Chris Watts case, all the police reports actually prepared by the report, by the police. And I think it's good for a lot of people because there are some theories going on out there that it makes you wonder whether they have actually ever read the reports and have just gone into complete speculation as to some of these theories. Now, could they be correct? Absolutely. However, that's really just not what the evidence is. And when we talked about the Chris Watts case and his interview by the FBI, Colorado Bureau of Investigation, he clearly, obviously admits to killing his daughters. The question is, do you believe what he said as to where he said it? And as it relates to Chris Watts, obviously that was originally a death penalty case here in Colorado, and the DA didn't go forward with the death penalty. A lot of it had to do with Shanann's family, who didn't think the death penalty was a just system or just punishment because of religious beliefs, which some people have. Say that, you should never kill anybody. Other people, it's an eye for an eye. You kill somebody, we are going to kill you if you're convicted. But we've talked about it. There's lots of issues related to the death penalty. Is it fair? Is it more likely to be used against people that are minorities? It just depends. Okay, Janie XX unsubscribed. Appreciate it. Thank you. That's all right, because we here at Crime Talk, we're not looking for one particular theory. Let the people decide. If you want to engage in an intellectual conversation, let's talk about it. If your opinion is the only one that's correct, okay, so be it. You don't have to listen to what anybody else has to say. It's your choice, and that's what I love about YouTube, is the ultimate free market capitalist type of system. If you like what you see, you can subscribe. You can watch. If you don't like it, you can unsubscribe. That's okay. We're not here to change everybody's minds. You don't have to believe whatever I say. And frankly, I'm not necessarily interested in espousing all of my opinions on everything in this particular matter. It's more to get people to think about it and talk about it. And if your opinion is reaffirmed by what you hear, or maybe you change it, then that's fine. This isn't like some of the channels on YouTube where this is my theory, and if you don't follow it or believe it, then leave. We're here to talk about the facts. We're here to talk about the law. And if you want to ignore that, the facts and the law, this probably is not the channel for you. So the subscriber that said she was going to unsubscribe, apparently I said something that she didn't like, but that's okay. I'll still be here. It'll go on, and we're going to be the ones that are going to talk about the facts. We're here more interested in the truth than being right, because frankly, that's more important than just saying I am right and I am correct. I can live with that. I can live with that. This is, I've done this because I want people to talk about the judicial system. I want people to understand the judicial system. I want people to actually look and say, should I believe what the newspaper's telling me by some reporter that went to journalism school that doesn't know anything about the judicial process? For those of you who've been around, I'm a criminal defense attorney. I've been doing this for almost 25 years. I've handled more murder cases than I can even recall or remember names to over the years. But I think that lends a little bit of credibility versus some guy who's never, been to a courtroom, is not a detective, is not ever been in law enforcement, never been in a courtroom, never represented a criminal defendant, doesn't know how the legal process works, wouldn't know what the rules of evidence mean, why things come in, why things don't. And that's really it. Oh, Adrian 411, quick Barrett update. The court today granted cameras in the courtroom for the arraignment for Mr. Frazee, who has court this Friday. And that's permitted under the law. The press just has to get permission from the court to do that. Certain steps have to be taken to protect basically, people's identity. But arraignment's going to be super, super quick in Mr. Frazee's case on Friday. The significance of the arraignment is that's where somebody actually formally enters a plea of guilty or not guilty. And Bren Lee, drinking tea from your Crime Talk mug. Now, I too have a Crime Talk mug right here. And if you like it, you can get one. It's usually on the screen below, or you can go to Teespring and order the mug and have some sweatshirts coming here myself. And we have some coffee mugs coming, some excess coffee mugs. So we will try to give those away, or try to come up with a way to give those away. Perhaps if we go live, we can, decide who has the most interesting question for that particular day, and send one to that particular subscriber if they do that. Kel, aka Happy Fox, what's the other side say? Let's talk about it, because that's what we're due. Let's talk about it. Like I said, this isn't Scott is right on everything. Here's what I'll do, is I tell my clients, I will tell you the good, the bad, and the ugly about a particular case. And I will give you my opinion or advice or interpretation as the facts that we know it. And guess what? My opinion will change if new facts are developed, just like everybody does in life and decisions that they make. And we should do that. If you're open-minded, if your position is someone is absolutely guilty, which they very may well be, but if you're not even willing to listen to some of the other sides of it, I mean, frankly, like I said, that's not being very intellectually honest. In fact, it's intellectually dishonest. And we try to be honest on all things. If we know the answer, we'll tell you. If we know the interpretation of it, we'll tell you. If we don't know, I'll try to find the answer. We will look it up. Oh, Janie XX. Looks like you're back. I'm not sure. I see question marks there, but I thought you had unsubscribed. But thanks. Glad that you're back. So anyway, so Mr. Frazee, he has court on Friday. The court's allowed press to be in there. It'll be quick. A couple things will happen. I doubt he will enter a plea. The defense could ask for another continuance of the arraignment. More than likely, the court will not allow it because they want to move cases along. And judges here in Colorado have to deal with the Colorado Supreme Court Chief Justice directives that basically they want these cases, unless it's a serious case, really to be resolved in no less than 1 year from the time that they're initiated. So at that arraignment date, assuming Mr. Frazee enters a plea of not guilty, that will start the speedy trial clock. And under Colorado law, Mr. Frazee has a right to have the state bring him to trial within 6 months from that date. So if we're in April, I think that's the 5th, this Friday. So the state will then have until October 5th of 2019 to get Mr. Frazee to trial. If for some reason the state didn't get him to trial, the case would have to be dismissed as a matter of law, but I assure you it will be tried before that. The judge will probably set a trial date sometime in September is my guess, and the court will then set motions will be due. Legal motions to be resolved have to be filed usually by each side within 35 days. Judge may ask for a little more time, and then a motions hearing date will be set whereby the judge will actually decide legal issues. And what I mean by legal issues are matters of law. If there were any statements that were made by Mr. Frazee that we're not aware of, those motions to suppress may be filed. If there's been many search warrants on this particular case, then the issue will be whether those search warrants were obtained legally. Were the items that were seized, were they within the scope of the search warrant, or did they go beyond the search warrant? And those are all things what the judge decides what evidence is coming in, what's legal or not. Barbara Town, the Watts case is over. Time to move on. Yes, the Watts case is over. I do believe that obviously Mr. Watts is not getting out. He's never going to try to withdraw his guilty plea. He has pled guilty to those charges. But a lot of people still have interest in it because a lot of people still want to try to understand why could a man actually kill his pregnant wife and 2 children. Oreo, let's see, let's got a super chat here. Let's do this. Oreo Cream Rocks. What do you think about citizens' reviewers of cold cases for new leads through fresh, unbiased eyes? I have no problem with that. If you think about it, that's how the Innocence Foundation started. And they started looking at cases where they thought people were innocent, and they sought cases where they could try to see if DNA evidence would clear people. As a society, we should want the judicial system to work. And it only works if we truly put the bad guys away, but we certainly don't want to punish innocent people for crimes that they did not commit. Who would want that kind of injustice coming along? Indy Starin, thank you for the super chat. You are a Crime Talk aficionado. Thank you very much. Thank you for subscribing. Thank you for watching as well. Let's see, I was on a jury in Teller County for just a theft case. Let's see here. Lost it here. Let's see here. And the last month for charges dating back in 2016. They are slow. Cases can get bogged down in the legal system sometimes. Sometimes that's just the way it works. You don't know if there are other issues, if there are witness issues. Maybe the defense is okay with slowing it down. Maybe somebody doesn't want a trial. There could be reasons maybe somebody was not mentally competent to proceed, but they were restored, so now they're going forward. Michael Smith, DNA confirms and convicts much more people than it exonerates. That is not necessarily an untrue statement at all, because it does. It's a process of elimination. It eliminates people. It matches people to it, but it is not absolute. DNA evidence can be transferred relatively easily. In cross-examination, I ask DNA experts all the time whether, for example, if I'm standing at the podium, and since DNA can be transferred from cells or sweat or something along those lines, and if there was a crime committed at that podium where I was, and they swabbed it and my DNA was there, it doesn't necessarily mean that I committed a crime. It just simply means that I was there. It's not always useful in some cases, because if the crime was, let's say, in somebody's house, you would expect to find my DNA in my house or where I was. It doesn't necessarily mean that somebody committed a crime, just that they were there. So yes, it can cut both ways. It just depends. Emily, moral of the story, keep your hands to yourself. Absolutely. Let's see, let's see here. Oh, he Ranger, doesn't the right to a speedy trial help the defense in most cases? It depends. Like I said, the state has a right to a speedy trial. In the federal court system, it's much faster. Basically, it's 70 days. In a municipal court system, sometimes it's as little as 90 days as well. But you have to move cases along as quickly as possible because witnesses disappear, memories fade, and that is the good thing about scientific evidence, is it doesn't forget. Its memory can't be influenced by anybody. They can't disappear. It is what it is. So it is a great tool. I agree with you on taxes for the wrongfully imprisoned. Lizzie Shoes. Yeah, I mean, if people are wrongfully convicted, they should receive settlements. I'm a firm believer that if there's misconduct by the district attorney and they withheld evidence and somebody was convicted, that there should be sanctions against the district attorneys if it can be shown that they have acted improperly in any way. If it was just good old-fashioned mistake, people truly believed it, and that's one of the issues that you obviously have in any criminal case, is to eyewitness identification. It is not that reliable. The studies show that people can be influenced by what they think they saw, what people wanted them to see, so it really just depends. Let's see, I hope. Refreshing to hear Scott hear facts and not fiction. Some YouTube crime talks are simply, they make stuff up on the basis of it's an opinion. I have watched many YouTube channels just to see if, hopefully, if we're doing it correct. And I don't think there's a necessarily a correct way, but there are a lot of people that have their opinions. And like I said, God bless them. YouTube is fabulous. And if they have people that want to subscribe and follow them, more power to them. Like I said, I'm more interested in people learning about it and presenting the facts. Let the chips fall where they may. I'm not emotionally invested in any of these cases in a particular way. So it really just it doesn't matter to me. Like I said, I'm more interested in the truth. What about the terrible living conditions in federal and state prisons? That's Manja Puppy 2009. Well, I can tell you the conditions in prison. I certainly wouldn't want to live in prison. Live in a small cell with a bunch of people that you don't necessarily know, but you may get to know real close after a while. I certainly want to do it. Lights on all night, loud, it's noisy. Wouldn't want to live there, but once again, goes back to cruel and unusual punishment. Is it cruel and unusual to do that? Scott, a case out of South Carolina that never received justice. I can share, but would love to connect. Emily, you can send me an email at scott@scottreisch.com. If you have a link to some information, we can look at that. Let's see here. Yes, even lawyers can have opinions. Look at the Smollett case as a prime example. Absolutely. I have an opinion on that. I think it was a raw deal that Mr. Smollett received, and not in the sense that he got a raw deal. I think the citizens got a raw deal. I think all of the individuals who were in a similar situation, the 16 felony convictions and didn't get a deferred prosecution, got a raw deal. So thank you. Let's see, NAF Carr, thank you for the channel. I appreciate it. Thank you for the super chat. I appreciate that. Alexa, finishing your bachelor's and going to do paralegal studies. Would be very someone to become a paralegal and struggling with availability to loans. Alexia, I would, if you want to be a lawyer, you can be a paralegal. You certainly can. It's an important job. We employ multiple paralegals in my firm and frankly could not live without them. And they are frankly oftentimes more important than any of the attorneys. They do a lot of the real work that needs to get done that if it weren't for paralegals wouldn't get done. But if you want to be a lawyer, my advice is go to law school. You can do it. There's so many programs out there these days for people to go. Yes, it's expensive, but if it's important to you, you will figure a way to do it. Let's see here. Sometimes these super chats go away. Emily, there are YouTube videos that show brutality, beatings, malnourishment, torture. That happens in prisons. The mentally ill, elderly are obviously horrific. Bad things happen in prison. I've represented people on cases, whether it be introduction of contraband, to prison gangs, to homicides in prison. Prison is a scary place. I've been to many a prison to investigate murders in a prison. Doing our investigation is good. Like I said, I certainly wouldn't want to be there at all. And the rules of the real world do not necessarily apply because it is a very almost barbaric system when you get to prison, and it's not like who's the smartest is going to be in control. It's usually who's the biggest and the strongest. But I have a great book, and man, I should wish I have the name of it off the top of my head. Maybe next time I'll pull it. But it talks about how prison systems work, how the wardens actually give legitimacy to prison gangs because they use them as tools to basically keep the peace. They have to negotiate with them. They become in power in prison, where they'll try to make sure that nothing bad will happen. There won't be a riot. There won't be retaliation. They'll go to what they refer to as shot callers and say, don't let anybody do anything stupid, whereby they can, let the peace go away, breach of the peace. So, all right, well, we've been doing this for almost an hour. I appreciate it. It always goes by so fast. I appreciate it. Thank you for watching. If you're new to us, please hit the like button. And if you want to read the opinion itself as it relates to the Supreme Court basically changing 60 years of jurisprudence as it relates to the death penalty law, you can Google Bucklew, B-U-C-K-L-E-W, and read the opinion for yourself. It's about 60 pages, and Judge Gorsuch actually goes into a lot of details to the history of the death penalty, the means that were authorized and used over the years, and that, like I said, basically what it comes down to is that you are no longer entitled to a pain-free execution, just one where the government doesn't, quote, super add, end quote, to the pain and suffering of the party being executed. It's going to be interesting to see how this develops. It hasn't been in the news much because, frankly, it's not that big of, not that interesting to the everyday public, perhaps, but to courtroom observers, to Supreme Court watchers, it's a big deal. So, thank you for watching. ScottReisch.com here on YouTube. You can also go to our website, ScottReisch.com. It has information that we have put up. I believe it should have gone up today. The police reports from the Smollett case. All the Chris Watts discovery is there, some 1,600 pages. You can read all the texts, emails, things of that nature. You can also subscribe. If you subscribe, we will send you some emails about interesting things going on in the law if you choose to do so. And like I said, if you would also like your mug, I just love this design here. You can order those as well by going to the site. Thank you, and let's see here. Duff Steer, I hope your plane is running better. Haven't heard from the mechanic yet. That worries me. That usually means it sounds expensive. It's going to be expensive. So thank you very much for listening. Thank you very much for watching this evening. Like, subscribe, and I appreciate all that you do. Couldn't exist without you. Have a great night.